Hi, I'm Greg Dell, joined by attorney Stephen Jessup, and we're going to talk about Lincoln Financial disability denial claims. And Stephen, we've seen probably thousands of Lincoln Financial disability denials, and there are some nuances that we were just talking about with them before we got on. But the point of this video is to let people know how we can help them with Lincoln Financial appeals, Lincoln Financial lawsuits, things that they should expect if they dealt with a denial, because a lot of people watching this video don't even know, like, they just got their denial and they don't know what the next steps are. So let's get into where denials start before even a lawsuit happens and why there's appeal process, why they have to do that, and the first steps to take for a Lincoln Financial appeal.
Yeah. So when you get your denial letter, these are employer provided policies, and that's going to be governed by federal law, ERISA, the Employee Retirement Income Security Act. And as a matter of course, it requires that you go through one level of administrative appeal at a minimum. Like we said, there are some nuances with various Lincoln policies, but you have to go through the appeal process before you have any rights to bring suit, right? And I think there can become kind of an issue because people try to rush that appeal process. And as we've discussed in many other videos, the appeal is the most important aspect of your claim because it's going to set the tone not only for the ability for you to get back on claim, but then also any future litigation as well.
And when people get this denial letter, it often says that you have rights under ERISA. What does that mean?
Well, you have rights to ask for an administrative review. There is always an inherent conflict of interest because that review is done by Lincoln. They just denied your claim and now you're going to appeal to them and they're going to see if they were wrong. That being said, there are requirements under the law that when you do a mandatory level of appeal, it has to go to all new, claims people in the appeals department and doctors, people who've never looked at your claim before with a fresh look to see if the right decision was made by the claims person. ERISA also gives you the right to requesting and get a copy of your claim file. If you're on claim and you say, hey, I want you to send me a copy of my file, they don't have to under the law. But the minute they deny you, they have a responsibility and duty upon written request to give you a complete copy of the claim file, which is basically everything, anything you've ever submitted or they've created, during the course of the claim.
So this ERISA denial, which is governed by ERISA, a lot of people call and they go, I just want to sue them.
Mm-hmm.
And because they're angry, and that's all a lot of people ever know, because they think when you get involved with an insurance company and they violate your rights that you have to sue them. Well, number one, as you just said, under ERISA, you're not allowed to. And the reason it is ERISA is also because it's an employer provided policy, which is what almost 98% of the stuff I've ever seen from Lincoln, because you can't really go buy a private disability policy on your own. So you are governed by ERISA. But it's not such a bad thing that there's this appeal process because of the fact that we know how long it can take if you have to file a lawsuit. The other advantage, and I like to talk about advantages because there's a lot of negative stuff out there about ERISA, but the other advantage is the fact that you get this claim file that you mentioned, and you don't have to engage in this 6 month to 1 year long discovery process of doing interrogatories, which are sending questions to the insurance company, requests for production. You as a claimant don't have to be deposed. You don't have to go and depose all of their doctors. When I talk about this in a positive, yes, we would like to depose their doctors if we could, but it works the same way for both sides. And so basically what we're getting is we're getting all of the pieces of the puzzle, basically, and saying, this is what it takes to put together. There's 1,000 pieces. Here's everything. Now go ahead and respond. Now in the appeal, we have the option without the rules of evidence to do whatever we want, however we want, and give Lincoln every single piece of evidence that we think supports our client's denial. That's really nice because in a lawsuit, it doesn't work like that.
Correct.
In a court of law, you have to comply with the rules of evidence and you have to meet all of these different standards before you can just submit evidence. Here, we can put in everything. And if we lose the appeal, the court has to consider every single thing that we put in. So when you're doing a Lincoln appeal, what are the most important pieces of evidence that you're relying upon in order to win the appeal?
It really depends on the nature of the disability, right? Is it a physical disability? Is it a mental health disability? Understanding the diagnosis is going to lay a foundation as to what information you want. I guess the easiest way to answer that is as much objective evidence as you possibly can. If that's a pain problem in the back, MRIs, if there's nerve conduction studies, functional testing, things that can be done to provide objective evidence of what Lincoln's going to deem subjective complaints to be, whether that's fatigue, pain, depression, anxiety, whatever the case may be. It's bolstering up as much tangible, evidence as you can outside of the medical records and outside of, what the person's, has their complaints in those records.
So what I want people to understand in terms of what we do when they hire us for an appeal is we are basically at the end of the day putting together a final appeal package. I don't even like to call it a letter because yes, we're going to write a detailed letter to the carrier explaining our position as to why benefits should be paid. But I always like to tell claimants that 80% of the work that we do is in gathering the evidence that's going to go into this letter. So it's not about just telling Lincoln everything they did wrong or throwing a bunch of legal jargon or case law at them to say you did all these things wrong. It's about winning it on the facts. And the way we do that is by working with the claimant, our client, working with their doctors, working with vocational experts, working with other consulting experts, whoever they may be that are needed for that case to make Lincoln get this package that we submit where Lincoln basically says, how could any reasonable person think that our client could go back to work? And that's the goal. Unfortunately, we get a lot of claims that were done by other lawyers or that claimants did on their own. And we see that they've left themselves basically in a position where it's going to be very hard to win their lawsuit because they haven't put in a lot of evidence, or they hire a lawyer who doesn't understand this area of work and has just thrown a bunch of stuff at the carrier where they basically told Lincoln, here's what you need to do. Lincoln goes and does all that. They didn't necessarily do it reasonably. And then it's hard. It's hard to make a winning argument, which is where I want to transition into if you lose your appeal, what are your remedies? What can you do at that point? And so that goes into what we call the Lincoln financial lawsuit. Talk about what that process is like.
Yeah, and this is also important to know, and this is something that needs to be addressed. Years ago, Lincoln bought Liberty Mutual, their disability life insurance products. And for what period of time, they had changed the name of the company that Liberty was under. It used to be Liberty Life Assurance Company of Boston, became Lincoln Life Assurance Company of Boston. But then they took on the formal legal name of the underwriting insurance, Lincoln National Life Insurance Company. So your denial letter will just have Lincoln National Life Insurance Company without an understanding of who the actual original policy was with. And why that's important is those old legacy Liberty Mutual policies, you only get one level of appeal. The Lincoln National has mandatory 2 levels of appeal. And even when they deny your case on the first one, they don't make it clear that you have a duty to appeal a second time, right? So it's very important to know what you're looking for, what we're looking for, and to determine, is it the right to sue now, or do we have to go through a secondary appeal process? But saying everything's, a final denial, everything's done, at that point, the only legal remedy at that point is to file a lawsuit under ERISA in federal court.
And the process of filing a lawsuit in federal court is something that we have the opportunity to file in federal courts across the country because it is governed by federal law. And that is something that we do. And we try to pick the best jurisdiction that's going to provide the best case law, even though a lot of the case law is relatively similar throughout the jurisdictions, unless there's some kind of real legal strategic move that we find to go to a particular jurisdiction. It often doesn't matter that much which one that we would fall in. But when you end up going to litigation, let's fast forward to, is there a trial? Is there not a trial? What is the process that people know? Because I always tell people this is not what you see on TV. And why do we always say that?
Yeah, and it's even to other lawyers who've never done it. It's not what you see on TV. On TV, they show this idea of you getting your day in the court, telling your story to a jury, cross-examining, their doctors and this, and you testifying and all that. And none of that exists in this area of the law. Kind of going back to the appeal in the sense, there's this administrative process that they try to make as simplified and expedited as possible. Litigating these cases are the same as well. You don't have the right to a jury trial. It's only going to be a judge making the decision. You as the individual don't testify. Your doctor doesn't testify. No one from Lincoln does. And quite often, a lot of times, the judges, even in trial, don't even want to hear from the attorneys. These cases are decided on motion. So it's a very, kind of draconian, cold area of the law. There's really none of this, what people think about in their day in court, if you will, or people who've gone through the Social Security Administration process at the behest of Lincoln. You may have an ALJ hearing with Social Security where the judge actually at least asks you questions. None of that's going to happen now. And then us as plaintiffs, we have a two-step process. One, we have to show that Lincoln got it wrong, that the person is denied. And then, if we show that, we also have to show that Lincoln was arbitrary and capricious in the denial or, didn't have reasonable grounds to deny it. That can be its own crapshoot as well. A judge can side and say, listen, I think there is enough here for it, but I don't think it's an unreasonable conclusion that the insurance company made. Sometimes it's very egregious, and other times, if it's a coin toss, if you will, the sentiment is to defer to the insurance company's, decision-making process. So this area of the law is very strange. But with that too, like you had mentioned earlier, no discovery and depositions, interrogatories, and all those things. Generally speaking, the litigating of these cases is much quicker than you would in other areas, to a point.
And what I also like to tell people about these Lincoln denials is that you need a law firm that has an expertise in having handled thousands of these cases, because the case law is what I always say, the wild, wild west. For every argument that we come up with and find one or two or three cases that support our client's position, there's likely going to be one, two, or three cases that support the defendant's position. And that's because so much of this, the case law in this area, is up to the subjective interpretation of the judge. So the judges are always looking at facts, specifics, to a case. While there may be cases that apply to Lincoln in the past because they've had many, many lawsuits, and then the judges, they determine whether or not they think the company acted reasonably in their review of the claim. And for every case we find that says they acted reasonably, there's another one that says they didn't. So you have to have a real mastery of the case law in order to represent a client appropriately in trial. You also have to stay up to date with what's going on. And every day we're getting multiple case decisions that come out in this world of ERISA disability lawsuits. It's probably outside of criminal cases. It's one of the highest rendered written opinions from courts. But the reality is, because of the fact that it is not, that I don't want to call it inconsistent, but that there's so many different ways to argue, that if you have a really strong case, the insurance company still thinks that they could potentially win. And sometimes if you have a weak case, the insurance company also realizes that they could lose. So it cuts both ways in what you have. But the last area I want to talk about in a Lincoln lawsuit is, what does a win mean? How do you define that as an attorney representing somebody?
I think the better term is recovery, right? This is a very difficult area of the law, under best of circumstances. It's a difficult burden for the, factors we've discussed, but really recovery, especially in cases, and there are cases that we've litigated where, especially if we didn't handle the appeal, we didn't have a lot to be able to argue. So we had to be, creative in crafting arguments, and during the course of litigation, federal courts generally mandate mediations, formalized, sit downs between the parties to resolve these cases. So, they're in a settlement, right? So if you win the trial, obviously, and you get your client back on claim, that's a win, that's a recovery. But even a settlement, and that settlement is usually going to always consider past due benefits as well as, a percentage of future benefits. So realistically, the money, I was speaking with a client earlier today whose appeal was denied with her carrier. And, as I always say to any client or prospective client, you've got nothing to lose. Realistically, worst case scenario is you're going to end up where you're at now, them not paying you. Yes, there's a possibility of attorney's fees and that, but the probability that's very low. So a lot of people, feel beat down, like they've been fighting for quite some time with the insurance company, and they're like, they don't know if they have it in that. So that's why also this area of the law, when it comes to, hey, you're not going to be deposed, they're not going to surveil you, there's no new information that comes in, it's just paperwork for the attorneys. I would say, stay in the fight, right? What they want you to do is walk away. There's always going to be money when you get into a litigation posture. And I think that's something that's really important for people to remember, because the claims process can just seem like being in an abusive relationship. They're always questioning whether or not you're telling the truth, whether anything you're sending is sufficient. And it's just this really deny. But once you're in the litigation process, there is kind of a difference because you're dealing with defense attorneys from the other side and stuff. And it's the legal argument at that point. So recovery and the idea of, are they paying you benefits? Usually in a settlement, there's a compromise. As a lot of mediators will say, a settlement is where both parties are mutually unhappy with the outcome. One side, Lincoln thinks they paid too much. The client thinks they didn't get enough, but there's at least, a guarantee of a resolution as opposed to leaving it in the hands of a judge. And like you said, the case law can be all over the place and you never know exactly where that judge is going to fall.
So the other type you talked about recovery could be through a settlement. The other thing is you could go to a verdict with the judge. And then what you end up winning that a lot of people don't realize is you win the benefits that are owed to you potentially either up until the day you filed lawsuit, maybe up until the day in which the judge enters a judgment. Usually it depends if you had been paid in the past, then usually the judge will enter a verdict up until the day in which the judge enters his or her verdict. If you've never been paid before, unfortunately, more often than not, the outcome is that the judge does what's called a remand, sends it back to the insurance company and says, in light of everything I said, please reevaluate the claim. At that point in time, you're 2 years likely down the road by the time a judge makes a final decision. The company then is going to only have medical documentation probably up until the day in which they made their final denial, not even necessarily when you filed lawsuit. So now they've probably gone a minimum 2 years without medical records. So now the insurance company is going to get everything back. They have the right and the opportunity to reevaluate everything. We don't know what they're going to do. They could deny you again, and then you got to go through the whole process again. So a lot of people have the conception that if you win at court, you're going to get all your benefits owed to that date, and the company has to pay you the rest of your policy period, which could be age 65, 67, lifetime, whatever it is. That's not the way it works.
Yeah, and that's what I explain to people, even when they get the initial denial, like, well, how can they do this? How can they do that? And I always like to discuss with any prospective client, even at the appeal stage, what litigation this looks like. And I think that frames why insurance companies do. We already talked about favorable standard review under the law. But like you said, their worst day in court may be just paying you the money they owe you.
Right.
So where's the financial disincentive not to act, like a jerk, So it's really, that's very frustrating. So a judge can say, yeah, you won, put this person back on claim and you get what you're owed, but then there's no guarantee of future benefits or, the judge can't order them to pay you or not deny you. It's just back to review. It's almost like the judge is acting as a second appeal, the review of he's just doing a review of the review done by Lincoln.
Well, one of the nice things for clients, and again, it doesn't happen all that often, but if you do prevail and the judge says, yes, I find that you've prevailed on the merits, the judge has the discretion, doesn't have to, but usually does, if you prevail on the merits, to award attorney's fees. When you have a firm like ours that commands one of the highest hourly rates in the entire country, it's going to be a very substantial attorney fee award, which helps to make the client whole. Now, we do whatever the client wants. More often than not, if there's an attorney fee award, we're going to get more money than the client would potentially get. However, a lot of people have to realize that all of the cases that we litigate are handled on what's called a contingency fee basis, which means we only get paid if the claimant recovers benefits. And that's a percentage of whatever their recovery is going to be, which is something we'll discuss with the clients because it's not etched in stone. It depends how much the benefit amount is, how much period of time they're going to collect. And that's a flexible process that we discuss, with each and every client. But there is a small deterrent factor to the insurance company because they know when we're on the claim that the court is likely going to award our law firm and our attorneys the highest rate. And so the insurance company is already paying their law firm $50,000 to $100,000, depending on how many hours it is. And then they're going to have to pay our law firm based upon the hours we have. So that's a little bit of a deterrent. Another reason that when you go at a strong law firm, you're going to get bigger value, bigger settlement offer because they know that if they lose, they're going to have to pay a lot to the other law firm. So this was good to touch the surface on denials from Lincoln, which basically means we can help you in an appeal, we can help you with a lawsuit. But what I like to always tell people is that if you have a denial, feel free to reach out to Stephen, myself, any of our lawyers. No matter where you live in the country, email us a copy of your denial letter, give us a call. We'll immediately get on the phone with you, provide you with a free consultation, and we look forward to the opportunity to speak with you.